applicable. As I said, as to the allotment of debentures, the special provision applicable to the first allotment of shares also applies with the issuance of debentures too, except the amount payable to the application, that is 5%, and the deposit of application money in the separate scheduled bank account. Except of these two, every other things are applicable. See, what we understood here is this, my friends. When the shares are being issued by the company, they have to follow a special provision, that is general provisions, and also the special or statutory provisions in respect of any allotment. If there is a failure on the part of a company to comply with these requirements, then the shares which are so issued by the company becomes void or voidable at the option of the applicant. So this would result out into the consequences of irregular allotment of shares in the company. Section 40 of the Act deals with the irregular allotment of shares and also speaks with the effects of such irregular allotment. And what are the consequences of this irregular allotment? The irregularity can be made where there is a failure to deliver the copy of prospectus to the registrar, then the company liable and also the directors are liable. The non-compliances with any of the provision of section 39 or with the statement in lieu of prospectus, company or the members are liable. Condition as to the listing of shares in a recognized stock exchange, company or the members liable. In all such cases, my friends, where if such violation is being made, irregularity is committed in respect of any such allotment of shares, then the contract is void at the option of a shareholder, and the company has to hold a meeting within 2 months of the allotment, or where if the company goes for a winding up within 2 months, then the contracts becomes voidable in nature. So these are the procedures which is required to be complied in respect of allotment of shares and also the consequences of irregular allotment of shares. The next topic is with the call of shares by the company. When I say the call is not something a different form of a share, but a call is a voice made by a company calling upon the unpaid shareholders to pay their money which they have a balance to the company. Or we can say a call is a demand made by the company for their shareholder to pay the whole or any part of the remaining unpaid amount on each shares. It may be in pursuance of the resolution passed by the company or by the decision taken up by the board of directors or in terms of the articles of association. And this call may be even during the lifetime of a company or even during the winding up of a company. Not only Companies Act but also SEBI shall also provide the rule in respect of the same and says that is such when a call is being given, then such shall be satisfied within 12 months from the date of which the company gives a call for its shareholders to pay the balance amount or unpaid remaining amount on the shares what they are holding in the company. Though there is a right on the power of a company to give a call for such unpaid amount which the shareholder is liable to pay upon to the company, but still the company has to comply with certain legal provisions relating to the call which the company gives in, and this rule or the law which is required to be followed by the company before making any such call to the shareholders for their unpaid balance amount or remaining balance amount on the shares of the company which they are holding with. That is, where a company gives a call for the unpaid amount, that is call of shares or call on shares of the company, the legal provisions which the company is required to comply with is, first, there shall be a resolution passed by the board for the purpose of making a call to the unpaid amount to such class of shareholders where the shares remains to be an unpaid amount and holded by them. The first one is the directors who are making for a call should be a person who is been duly appointed and qualified for having passing such resolution. Second one is the meeting of the directors should be duly conveyed in respect of having making a call for the company. There shall also be a proper quorum to be present in respect of any such resolution to be passed in the company and as prescribed by the articles of association. And the fourth one is the resolution of having making call should have been duly passed by the company. Only then the resolution of the board is said to have been made for having giving the call. The second provision is that there shall be that the call so made shall be for the bona fide benefit of the company, which says that is whenever when a call is being made, it shall not be for the purpose of just pulling the shareholder for his unpaid balance amount, but it should be for the benefit of company and it should have been exercised with the good faith. If any doubt or if any such latches that is being made in respect of having giving a call, then such call becomes an invalid one. The third one is every call so made shall be made on uniform basis. That is, the call must be made to all the shareholders falling under the same class of shares. That you cannot select a group of person or group of shareholder for which a call is being given. It cannot be made. It results to be as an invalid call that is being made by the company. So wherever where the call is being made by the company, the call shall be made at least to all such person who falls or who comes under the category of the same class of share which the company has issued with. So also the fourth one is what if in case of call made in advance? When I say advance, my friends, the company at the time of issuing the prospectus itself and having taken an application money, the company may give out a term of having paying the money which is unpaid one. So on every such stage of such payment is required to be made by the shareholder. However, the company may have a power of having making a call in advance. That is where if it is authorized by the articles of a company, then if it is also accepted by any members of a company whether whole or in part, then the amount so remaining unpaid by the shareholder can be taken up by the company in advance. The payment of call in advance does not give a voting right to such member in respect of any amount until the amount so currently or presently becomes due on the part of the shareholder. So such a rule has to be followed in respect of any such call that is being making. And fifthly, every such call shall be made in accordance with the article, and the amount and place of payment should also be very clearly specified by the company in respect of any such call is being made. Apart of these legal provisions, there are also such other regulations which the company is required to follow while having making a call from their shareholders. That is, no call that is being made by a company shall exceed at least 1/4 of the nominal value of the shares at one time. I repeat, no call should made by a company should exceed 1/4, that is quarter of the nominal value of the shares what is being issued by the company or unpaid amount what is being liable on the part of the shareholder to the company. The second one is that is any such amount payable by a shareholder shall not be called to pay less than 1 month from the date of which it has been fixed for a payment from the last preceding call. That is, if the call is once already been made, then from that day of a call, at least 1 month gap has to be given to the subsequent call of money which the company is seeking for. The third one is at least minimum 14 days of notice must be given to the shareholder for the payment of money, and the time and place for the payment of money should also be specified with. The board of directors should also have authorized to make a call, and if the payment is not being made in time, then the shareholder may ask to be called for a further sum of money, that is interest at the rate of 5% per annum for such money what is being unpaid by them. So subject to these things, we shall see that the call can be made only when having satisfying these criteria. We shall say that the call so made by the company is said to be effective. Any lapses on this part, latches on this part would result out in the call as an invalid one, and the company cannot enforce upon such call when not paid for a forfeiture of a company. Friends, in between discussing with the call of shares and transfer of shares, I would like to come out with one small discussion or two small discussions. One is the share certificate and the other one is share warrant, which could be asked for your short notes. First is with the share certificate. Section 46 deals with the issuance of share certificate. In fact, share certificate is that when every person whose name is entered as a member in a company, that is under the registry of members of a company, for having received a shares from the company or the number of shares in the company, then the certificate of those shares has to be issued by the company to such shareholder. That is, after the allotment of shares and where the shares are being issued by the company, then the company is required to issue a share certificate for those of the shares holders for whom the shares are allotted with. And this share certificate so issued by the company shall be issued under the seal of the company or the emblem of the company or authentication of the company, and it shall specify that the number of shares to which it relates to, the amount to be paid thereon on each shares if there is any unpaid amount, or the name of the holder of the shares to whom it is issued with. And this should be issued by at least bearing the signature of 2 directors and 1 secretary of the company. This is very important. 2 directors and 1 secretary of the company. Why I am saying it is important? This could be asked for your part 9 question or part B question for a problem 1. However, the issuance of this share is subject to certain limitation, that is limitation of time of issuing the share certificate, which says within 3 months of the allotment of such shares made by the company has to issue a share certificate. Or where a case, if the shares is asked to be transferred from one person to another, then within 2 months of time after the application for registration of transfer for such share is sought, the share certificate shall be issued, where the share certificate issued to the promoters, directors, friends, relatives, associates, etc. It could be, then such share certificate shall also carry with an inscription, that is a message saying that it is not transferable for a period of which it is applicable or for which where the company has specified with. So with this, my friends, we shall see that the shares has to be issued. And what is the object behind of having issuing this share certificate? In fact, my friends, the very object of having issuing a share certificate would satisfy 2 criteria. One is it forms to be a prima facie evidence as to the issuance of shares and also the title of the member with whom the shares are being issued with. By this, the share is that which gives a power for the granting of a shareholder or providing an opportunity of a shareholder to a shareholder to deal with the shares in an open market and afford all such facilities to him by selling their shares at once by showing a marketable title to the effect, and this facility is to make a share a greater value. Or in a simple manner, I can say that it forms to be a part of evidence and allows the shareholder to deal his shares by showing his title in the open market and get a good value of the shares what is having with. The second one is that this issuance of share either way creates an estoppel as to the title and also as to the payment made by him to the company. That is estoppel. One is it is with the title. That is, if the company authorizes to issue any share certificate stating the name of a person with whom it is registered and a registered holder of certain shares, then the company afterwards cannot say that the person is not entitled to the shares of the company. In other way, we can also say like this: the name in which it is being registered with would be the actual holder of those shares, and the company cannot deny for the reason that the company is stopped from having denying to the holding of share by the shareholder. So the officer who is issuing has no authority to say that share certificate is not been issued, except where a case we have discussed that in Rubin versus Great Fingal while discussing with Indo management, if it is a case of forgery. The second one is estoppel as to the payment. It is not only an estoppel which creates as to the title, my friends, but also it creates an estoppel as to the payment of which the person is to be made. Suppose if the share certificate states that the shares are being fully paid up, and in fact the construction the view is this, that the shareholder has not paid it completely or has still a part payment balance is left out by him, then the company is stopped against the person from the shares which is holding. And the bona fide purchaser, if he states that it is not been completely paid upon with, then they cannot allege the amount of said amount in the share certificate. Or I can say that where if a bona fide purchaser claims to have a transfer of shares, and if the company cannot say that the shares are not being completely paid with, if the shares presents in its certificate showing that the shares are being satisfied with the capital of the amount with which it is being registered with. However, if a person knows that personally that the statement is not true, that the statement is not true for the reason knowing that it is not been fully paid with, then he cannot take the right of estoppel in his favor. So in subject to these issues or these objects, the share certificate creates a right on the part of a person, and for which the share certificate has to be issued by the company. The next one is the share warrant. A share warrant is a document issued by the public company stating that the bearer of this document is entitled to such specified number of shares in a company. It is, I can, in a simple way, I can say you is, it is Indra Vikas Patra which was being issued by the post office. And the object of issuing of this kind of share warrant is that it is easily transferable, that is by mere delivery of this document, that the holder of this document is entitled to the share certificate. So this holder is substituted in the place of the original owner. In fact, a public company limited by shares may convert fully paid up share into a share warrant, and the greatest advantage is just for its transferability of shares. However, the registration of such a case shares are not necessary. Condition for issuing a share warrant. See, in order to issue a share warrant in place of share certificate, the first condition is the shares shall be fully paid up. The article should authorize the issuing of such share warrant, and also there shall be a prior approval of the central government in respect of issuing a share warrant. And the fourth one is the share warrant shall be issued under the common seal of a company. In fact, when such share warrant is being issued, the company should enter the name of a person in the registry of members by striking out the register of members for whom the share warrant is being issued. By then, such a registered shareholder who has received a share warrant would cease to be a member of a company. However, the company shall instead enter in the register of members with following particulars. One is the fact that the issue of share warrant is being made, the statement of shares specified in the warrant, which can be distinguished each by the share and by their number, and the third one is the date of issuance of share warrant. But the question comes is, how would this shareholder, that is share warrant holder, would be entitled to that of the dividend? Friends, when the share warrant is being issued, the coupons attached to this would also be issued by the company. And when the dividends are declared by the company, the holder of the share warrant shall present a coupon before the company for delivering the dividend amount, and through which the dividends are going to be paid to the respective account in which they have been notified with. So this is how, my friends, we can speak or we can say with that of the share warrant. However, though it is not in my slide, I would also like to discuss two important things, that is issue of shares at premium and issue of shares at discount. I would like to briefly go, which is not there in the slide. A company can issue a shares at premium when it is able to sell the price above the face value of which the share is issued. For example, suppose if I am issuing 100 rupee per share, and that shares, if the company is able to sell the same with 160 rupee, thereby if the company do so, the company is earning a premium of 60 per share, and that excess amount of 60 is called as the premium that what the company can has received in. Or to say, if 10 rupee share is valuing today with 1000 rupee, then the 990 rupee what the company is worthing out with would be the premium on which the company is getting on its shares. So the Companies Act does not stipulate any condition or restriction regulating the issue of these shares by the company, but it only imposes a regulation in utilizing these shares which as received by the company as a premium amount which is collected on those shares. Firstly, the premium amount cannot be treated as a profit of the company, so this amount cannot be distributed. Secondly, the amount so received in cash or kind must be recorded in a separate account known to be called as share premium account. The third one is the amount of share premium is to be mentioned in the unmentioned and has to be also maintained with the same sanctity of which the capital that the company is got in. Fourth one, the share premium cannot be treated as a free reserve, and it is considered to be as a nature of which the capital is received with. However, the share premium can be utilized for the purpose like issuing fully paid up bonus share for their members, writing off the balance and preliminary expenses of the company, writing off the commission paid at discount or expenses incurred in issuing of shares or debentures by the company, providing for premium payable on redemption of any redeemable preferential shares or debenture holders of the company. For these purpose, this amount can be used, and the issue of shares does not require any sanction by the tribunal or any other authority for the issuance of these shares. And the rate of premium will be decided by the board of directors, and this subject to the compliance of the Companies Act and the Articles of Association or the guidelines issued by the Disclosure of Investment Protection Act issued by SEBI. In respect of this, the premium amount should be maintained and it shall be used by the company. This is one. And the second issue which I would also like to speak is issue of shares at discount. That is, discount is something where if the buyer of the share is required to pay less than the face value of the shares. Suppose example, if the shares are worth rupees 10 and if the company gives you the share at the cost of rupees 5, then that 5 rupees what you are going to save is something, the bonus which you are getting with. So those shares are said to be called as bonus shares. But the issuance of bonus shares shall be made only fulfilling certain conditions. They are like, the issue must be to a class of shares holders which the shares are already issued with. That is, it should be to the same category of shares which is already been issued with. Only to them the shares, that is, discount shares can be issued. And the second one is, not less than 1 year has elapsed from the date of issue of shares of the previous one has been made. That is, I can say, if the shares are already issued, the company within 1 year, it cannot go for the further issuance of shares at discount, or within 1 year from the commencement of business, the company cannot proceed for the issuance of this shares. The third one is, issue of shares at discount is to be authorized by the resolution passed by the company in its general meeting and with the sanction of the board. The fourth one is, the minimum rate of discount must not exceed more than 10% or such higher value as the tribunal has permitted under special cases. The fifth one is, shares is to be issued at discount must be issued within 2 months from the date of the sanction or to the company for the same, or such extended time by the tribunal it should be issued. And lastly, offer of prospectus at the date of the issue must mention the particulars of the discount the company is allowing with. In case of any default, every officer shall be punishable with fine which may extending to 500 rupees for every day of delay that they are causing to with. So these are the two things which I was supposed to speak, which is not there in the slide. That is, issue of shares at premium and issue of shares at discount, which can be, I'm not sure, can be asked for your short notes in the examination. Hello friends, today we are going to discuss what the transfer of shares, which is provided under the Act. In fact, in our previous discussion, we have understood that shares are a movable property as defined under Section 2, Class 7 of the Sale of Goods Act. And quietly, we should also understand that transfer and transmission varies with each other. So also at the first class of our discussion with what a company is, we understood that company is something which serves with certain advantages, and the primary of them is one, perpetual life and transferability of shares. And the more important thing that we should also know is that the popularity of the joint stock company is just because that there is a transferability of shares by their members. So a share in a company is something, a movable one, and it is transferred in the manner prescribed under the Act or in terms of the Articles of Association. In fact, when we look at the definition of Section 2 Class 68 defining what a private company is, there it imposes a restriction on the private company with the transferability of shares. That is, which says there is always a preemption clause on the part of a private company stating that there shall be no transfer made to an outsider. And if the transfer is to be made by the person in a private company, it should be made to an existing member of a company. And if any transfer is required to be made to an outsider, then it shall be made only with the prior consent of the board of directors through its resolution. But when we take with that of a public company, company has gained its popularity for the reason that there is a transferability of shares, and the public company considers shares as a movable property and is transferable in the manner prescribed to with. It is also provided that the right to share of any shareholder with his shares or stock is a statutory right, and it cannot be altered by any terms of articles of association, nor it could be restricted by the articles of association restraining the member or shareholder from transferring its shares. But it may have some restriction of right of a member in case of its transfer of shares as provided under the articles of association. In fact, the board of directors may refuse to register the transfer of shares when the shares are being partly paid up, or where the shares are with some deficiency or defect made out in it, or where it is not approved by the board of directors. However, the company in such case has to notify saying that why the shares has been refused to transfer with. But if a share is a fully paid up one, then within 2 months of time, the company has to transfer upon the shares, nor give a reason by its order through the board that for what reason the company has refused to transfer upon their shares. In fact, not only the Companies Act, the Security Contractors Regulation Act has amended in the year 1985 also prescribes saying that there shall be that is the company should ensure the transferability of share that the companies which are listed in the stock exchange under section 22 capital A. This section in fact prevails over the provision of section 44 of the Companies Act, which is sought to ensure the unrestricted transferabilities of shares or debentures, and says that this restriction can be imposed by the company only under these four circumstances. One, where there is a defect or deficiency found in the transfer deed like stamping or in the form etc., which is presented by the transferor or transferee, then it could be refused. Or where the transfer so made is in contravention with that of any other law for the time being in force, then such could be rejected. The third one is like where the transfer is likely to result in the change of composition of board of directors as it would prejudicially affect the interest of the company and of the public, then the transfer can be rejected. And the third one is the transfer is prohibited by the orders of the court or by the tribunal or by any other authority. These are the four restrictions which is imposed by the Security Contractors Regulation Act in respect of transferability of shares, and says that it is except of these two the company cannot refuse, and if the company doing so, the same should be notified to the person who is making his application for transfer, and it can also be challenged when it is arbitrarily acted with. The Security Contractors Act further provides saying that the company shall, before the expiry of 2 months from the date of instrument of which it is lodged, it shall make its transfer, or it shall make to the effect of registration on forming a opinion that registration ought not to be transferred, or intimate the transferor and transferee by notice as to what is required to be done to the effect of registration of this transfer provided under the law or under the articles of association. And also they are required to make a reference to the tribunal and forward a reference to the same for the transferor and transferee. In addition to all these rights of transfer, the transferee shall also have a right to appeal to the central government against the refusal to register the transfer. That is, it shall be made by a petition in writing and shall be accompanied with a fee of not exceeding 50 rupees, or as may be prescribed by the government, requesting upon the central government to look into or interfere into such refusal of transfer that is being made. So these are the things, my friends, where the transfer shall be effected, and in fact the Companies Act and also Security Contractors Regulation Act both provides a way or a gate wherein which the transfer shall be effected by a company, especially the public company, when the transfer is sought by the person. Let's also understand what is the procedure for this transfer. Mind this that the transfer is not complete unless it is being registered. So, for the purpose of registration of shares or debentures by a person who is holding it wish to transfer, then it shall be accompanied by 1. A certificate relating to the shares or debentures. Then if no such certificate is issued by the company, then at least the letter of allotment shall be filed before for the purpose of transfer. In fact, the certificate should be of a original one made by the person in respect of transfer in which he is seeking with. And this form or the application shall be presented in a prescribed form. In fact, 7B, form number 7B is the application which shall be filed for the purpose of transfer, and this should be presented before the register of companies, signed by both the transferor and the transferee, or by the transferor as required with, and the prescribed authority shall stamp or endorse thereon for such transfer. The another important thing which would also be made is that the period of delivery of this transfer deed. That is, the transfer deed shall be presented to the company in case of shares quoted on the recognized stock exchange, and or it shall be presented within 2 months of time from the date of the presentation of this transfer by the prescribed authority. In all other cases, the transfer deed shall be presented to the company within 2 months of date of presentation, and also in cases of any hardship, the central government may extend the period for delivery of instrument to the transfer. So, complying the first formality of all these things, then the company can proceed for the transfer. The transfer can also be effected by or executed by the legal representatives of the deceased member. That is, when the deceased person leaves behind his legal heirs, then the legal heirs would get a right over the property. Although they are not the member of the company and their name may not be registered in the registry of books of company as a shareholder, but still by virtue of the right what they hold in, they can effect the transfer by which they are entitled to the shares of the deceased member. And when the transfer is effected by them, it is understood that it is as good as it is executed by the member himself. However, the register or the company authority shall have a power to refuse for the registration of transfer so made by the transferor or transferee. So, subject to these procedures, the transfer shall be effected in a simple manner, to say with, that is, both the transferor or transferee or either of the one can make a transfer, can make an application to the transfer in a prescribed form, and the transfer is not complete unless it is been registered, and while having presenting this transfer, an application shall be made requesting for the transfer, and it shall also be presented in a proper form. The stamp duty payable on it has to be made, and it should be presented within 2 months of the time of the execution of that transfer. And if not, there it could be rejected, or where the transfer need not always be made by the member, even the legal representatives of the deceased member is also entitled to effect this transfer. Another important thing we should also know along with the transfer is the transmission, and we should also make down and understand the differences between transfer and transmission. So, whereas when we go with the term transmission, section 56 provides for the transmission of shares. That is, any person who becomes a nominee by virtue of the provision of section 72, upon which the production of such evidence as may be required by the board of directors, then the board of directors may elect the person to be a registered himself as the holder of the shares or debentures as the case may be, or may make such transfer of shares or debentures as the deceased shareholder could have been made from himself. and if the person being a nominee so becomes entitled to be registered as a holder of the shares or debentures himself, then he shall send a notice in writing signed by him stating so that he wishes to elect himself to be as a member of a company in place of the deceased father or the deceased holder. In fact, in case of Anil R. Chabria versus Phenolics Industries Limited, the court observed saying this: when the legal representative elects himself to become the member of a company, he may send the same in writing and signed with a notice called a letter of request to the company notifying his decision. If he elects to transfer, he shall notify it in election, then he can be executing the deed for transmission of shares, and all those rules are applicable as the same in case of transfer too. So transfer is something where a person voluntarily makes a transfer from one to the another. Transmission is an involuntary act which takes place. That is, to in a precise sense to speak with, transfer takes place by the person who is affected, but transmission is effected only when the registered shareholder dies or when a registered shareholder is adjudicated as insolvent, or where the shareholder of a company goes into a liquidation. So in all these cases, my friends, the transmission takes place. Let us also quickly understand the differences between transfer and transmission. In fact, my friends, as we have understood that the very first difference that we can make out between these two is that is transfer is effected voluntarily, that is by the act of the parties, whereas in case of transmission it takes place only by the operation of law, like where a person is dead, that is the registered holder dies, or where there is an insolvency, or where a person is suffering from any lunacy. In such cases the transmission takes place. The second difference is also that transfer takes place for a consideration, that is the transferee would pay to the transferor to the amount what is being so transferred or agreed upon with. But in case of transmission, there is no consideration is involved in case of such transfer. The third difference is also this: the transferor has to execute a valid transfer. But in case of transmission, there is no such prescribed instrument for the transfer, but the requirement is that only he shall make a notice to the company showing his intention to become a member of the company or to transfer to such person by a letter called a letter of request. The fourth one is, that is, as soon as the transfer is completed, the transferor liability ceases, and whereas in case of the transmission, shareholder or the transferee who is going to get his transfer by way of transmission would continue, and the liability would be the same as that of the original holder of the shares. So these are the differences we can make quickly with respect to the transfer and transmission. Friends, in this slide we are going to discuss with another important topic, that is forfeiture of shares. And in fact, the Security Regulation Act section 28 or rules 28 to 34 do also contain certain restriction as to the forfeiture of shares. But let us first understand what is this forfeiture. If the shareholder has been called to pay any call on his shares which he is required to pay on those shares, then if he fails to pay such call made by the company, then the company has two remedies with it. One is, it may sue him for such amount which he holds a balance on each shares what is holding by him. Or the second option left out to the company is, the company may forfeit his shares. And usually the company's articles would contain this provision or gives a power to a company for forfeiture of share of any member if he has failed to pay the installment on the issue price of the shares which it is being made within certain time or where the fact that there is a due on his part. So, forfeiture of share is something where a company taking a serious step which involves depriving the right of a person in respect of his property, that is shares, and it is exercised as a penalty to some act or omission caused by the shareholder. The company may also forfeit the share of a shareholder in following conditions are being satisfied out with the Security Contractors Regulation Act do also provides for the same. The first one is, that is, whenever the forfeiture takes place, it shall be made only in the accordance of Articles of Association, which means the forfeiture must be authorized by the Articles of Association of a company, and it is valid only when the provisions of articles are strictly complied with or observed with. In fact, a notable case which speaks on the accordance with the article, that is in case of Public Passenger Service Limited versus M.A. Kader, that where the court observes saying that the power of forfeiture exists in the articles of a company and it should be treated as a strictism juris. A little inaccuracy in complying with the condition would result out in against the company in having effecting the forfeiture of shares, and any effect of forfeiture becomes fatal on the part of a company. So, the right of forfeiture exercised by the company should be with the greatest exactness. It should be exercised by a proper parties, and it is also that, my friends, the forfeiture shall always be exercised for the bona fide benefit of the company which it is conferred on to the company. The second important requirement is notice prior to the forfeiture, which says before the shares are to be forfeited by the company shall first serve a notice to the defaulting shareholder requiring him to pay the unpaid call together with any interest liable on it. In fact, the notice must be given within not less than 14 days of time from the services of the amount due which the person is called to pay. State the event in case of non-payment of amount within the period what is mentioned in the notice. The shares shall be in respect of the call which it is been liable to be forfeited. Or we can say that the notice shall contain a detailed report of the shares which it is being called, the amount what is required to be paid, what would be the consequences if the non-payment of money, and when this non-payment of money should be satisfied to the company. It shall also specify the exact amount due of which the shareholder, including the interest payable on it. If the notice in any finds to be defective in any of the nature, then the forfeiture becomes an invalid one. In the same case, that is Public Passenger Services Limited versus M.A. Kader, the court observed saying this: services of a notice is an important and the proper notice is a condition precedent to the forfeiture, and said even where a slightest defect in the notice will invalidate the act of forfeiture. And the object of also having giving this notice is to give an opportunity to the shareholder for making his payment and also the interest on all expenses which is incurred to be paid on this. So in a way we can say it is a precaution or a caution given to the shareholder who is being not paid his unpaid balance amount by way of notice, and if this results out, and if not paid, this results out in the forfeiture of shares. The third thing is that even after this notice, if the shareholder does not comply to that of the notice what is being served, then the next step should be with the resolution of the board. That is, the defaulting shareholder, when not satisfied with the amount, the directors of the company may pass a resolution for the forfeiture of shares in a company. If the resolution is not been passed to the effect of having making the forfeiture or having causing the forfeiture, then the forfeiture or the act of forfeiture becomes an invalid one. Likewise, however, likewise, we shall also say that the provisions of the Companies Act gives a slight relief in this, saying that even a notice threatening the forfeiture incorporates the resolution of forfeiture as well. That is, when the company states that in the event of non-payment of any such amount or default committed by the shareholder, it is deemed to say that the act of forfeiture is to be instituted, then in such case no further resolution is required to be separately effected with. Otherwise than this, there shall be a separate resolution so passed by the company to the effect of forfeiture. The fourth one is it should be exercised in good faith. That is, the act of this forfeiture should be bona fidely benefiting the company, or it should be bona fide interest of the company. The power is only exercised when the relevant shareholder is not paying their calls. But the power cannot be exercised so as to just relieve any of the shareholder which he has a right to repudiate with. An interesting case which speaks upon the good faith is referred in case of Part-2 Trading Company. In fact, Mr. H and G were given with certain shares in the company to qualify themselves as a director. They paid nothing on the shares. Then the company was not doing well on the later day. They requested the company to cancel their shares. The shares were forfeited to relieve the members, that is these two directors, from liability. When the matter was taken by one of the members before the court held that H and G were liable to pay the whole of the nominal amount of the shares of which the forfeiture was caused, and it also set aside the forfeiture. So what we understand here is this, where the act of forfeiture is not benefiting the company. When I say benefiting the company, it should be to the benefit in toto as to the company, which includes every member, shareholder and all other persons who are interested in the company. So when a shares are being forfeited, it should be for the benefit, and if it is not being made to the benefit, then the forfeiture becomes an invalid one. Friends, the question for on this case law could be asked for a problem to your examination. The next issue is this: what would be the effects of this forfeiture? That is, when the forfeiture is followed in accordance with the Companies Act or in terms of the rules laid down under the Security Contractors Regulation Act, then what would the effect of this forfeiture be upon those persons whose shares are being forfeited? One, the first effect is it ceases the membership. That is, a person whose shares are being forfeited would cease to be a member in respect of those shares what is being forfeited. But withstanding to this forfeiture, he remains to be liable to pay to the company all such money which at the date of forfeiture is liable to pay upon to the company in respect of shares. For example, I can say you like this: suppose on the day of which the forfeiture is effected, if there is a liability arised because of the loss in the company, then to the extent of what is holding, he shall be made liable against the company. The second effect is this: it is not only with he loses the membership, but also it ceases the liability what is holding. The liability in the sense, a person whose shares has been forfeited, when the company receives the payment in full, then such a money what is liable to be paid on shares shall be seized with all those liability. In fact, when forfeiture is being effected, he would get nothing, and the penalty could be deducted from out of those shares what is liable. If the company is wound up more than 1 year after the forfeiture, then the member whose shares have been forfeited cannot be made liable. But before 1 year, for what all the liability that could comes in, that is, the person should take the burden of those forfeiture of shares. The third effect is, that is, shares becomes the property of the company. The forfeited shares becomes the property of the company, and this may be reissued by the company or otherwise disposed of in such manner as that is been provided or the board thinks fit in this regard. The purchaser who would also be liable to pay all those called dues of the share unless otherwise provided by the article in the articles of association.